All right, let's talk about the student loan cases. Now, about a month ago, the Eighth Circuit put a temporary stay on this case. It was a case brought by, I think, six Republican attorney generals who were arguing that, there was a question as whether they had standing, and they had to prove that they had standing by saying that they had invested in some private loans, and there was a conversion mechanism that ended before September, before this program kicked in, that would have basically meant that their states could potentially lose money, sort of like a bank shot loss of money, I guess you would say, under this program, which would have given them standing, and they could argue that it wasn't legit. Just yesterday, the Eighth Court enjoined it, which made it a little bit less temporary, right? Or did they halt the program? And this is not to be confused with a Texas judge who also halted the program, I guess, a week and a half ago. And now I know there were two different authorities that President Biden could have theoretically done this. One was under the HEROES Act, passed in the wake of 9/11, which said that the Department of Education, under the auspices of the presidency, could forgive debt if it was connected, important word apparently, to any type of national emergency, which would have inhibited people's ability to pay back that debt. Connected as opposed to concurrent with, so that, you could argue that was the auspices in which this loan forgiveness happened under the HEROES Act. Is that what made this susceptible to these challenges, or was it something else?
These judges were always going to find a way, I think, to block this law. I mean, I think or this program, and you can see that because they're concocting these ridiculous theories of standing. And you laid out one, like Missouri has this student loan processor that has the name Missouri, the word Missouri in its name. It's called like the Missouri something. It's not a part of the state. It's not a state agency, but the state of Missouri somehow persuaded the Eighth Circuit that it is, and got this preliminary injunction against the program. And I think it's worth noting, this injunction, it was 5 pages long. The number of sentences devoted to analyzing whether this program is actually legal, 0. The Eighth Circuit devoted 0 sentences to analyzing whether student loan debt relief is lawful. Instead, it spent 5 pages explaining how this was such a big deal that it had no choice but to put it on hold indefinitely. That is not a court that will care exactly which statute the Biden administration uses to justify student loan relief. That is a Republican court that is hungry to halt this program by any means necessary, and will not even bother to justify its decisions on the basis of law, because it has the power to step in and do whatever the hell it wants.
In Texas, the judge used the major questions doctrine, which you've talked about on this program. It is a made up whole cloth in only existence in the past 9 years. And there's no definition of what constitutes major in the major questions doctrine. It really just seems to be like, when we think something's like important, then it is.
This is going right back to law versus policy. The major questions doctrine is a policy veto over laws that conservative judges don't like. They don't like the Clean Air Act. Major questions doctrine, shoot it down. They don't like student debt relief. Major questions doctrine, shoot it down. Elena Kagan called it a get out of text free card, and I think that's exactly right. I don't really understand how any one person can decide what is major or not. I had thought that the court simply had to say whether Congress passed this law and allowed this regulation or not. But we're in this new era thanks to the Supreme Court's decision over the summer in West Virginia versus EPA that gives these conservative judges a new tool to just do whatever the hell they want. And that's what this judge in North Texas did. He is a Trump appointee. He is one of the worst. He barely even pretends to be a judge much of the time. His theory of standing was even worse than Missouri's, but he still decided that this program was a major question, so it had to be authorized by Congress. He quoted quoted some CNN article in which Nancy Pelosi said this had to be done by Congress, and said, well, that's enough to prove it's a major question. Congress got to do it. They didn't, so I'm blocking this nationwide.
So that has nothing to do with the authority. And we should say, in the American Rescue Act, Congress did actually say that you can forgive this debt, and it doesn't need to be subject to income tax. So Congress contemplated the forgiveness of this debt. Congress contemplated that the president had the power to do it, because why would you essentially do some of the cleanup for an act that you think is not authorized to do in the first place? Right? Like, why would you say debt forgiveness from the president will not be subject to income tax over the next 3 years if you didn't think the president had the authority to do that?
Right. We call that legislative ratification, and it's a huge issue in this case. It's so obvious that Congress envisioned student debt being relieved because, as you said, it exempted student debt relief from income tax for the next 4 years, a time-limited period in which it clearly expected student debt to be relieved. There was a very similar issue in the eviction moratorium case. You remember that case when the CDC had the eviction moratorium? Congress, in one of its COVID bills, identified the CDC's eviction moratorium and actually extended it by law and said, we like this and we want the CDC to keep doing it. And yet the Supreme Court still said that Congress had never approved an eviction moratorium. So it's all Calvin ball here. You cannot look at the words of these laws and look at what the courts are doing and find a clear connection. You see these courts imposing their very clear policy preferences, which are debatable. Reasonable people can disagree, but very little of this counts as true legal analysis. And most of it is just the Republican Party platform being implemented through the courts.
Again, I ask this because there are some in some circles who are arguing that the Biden administration purposely contemplated that the use of the authority that they're using would be shot down, and that there's some other bulletproof authority that they could have used if they really wanted this to happen, which is not to say that they won't try, because they've already made like multiple changes to this program once the legal threats to it became apparent, including stopping the conversion of public loans into, or private loans into public loans, and changing, you can opt out of getting debt relief so that nobody was obligated to get debt relief, which was one way that they avoided some people having standing. So they've been doing this, and they could probably find a different authority in which they would deal with it. But I don't understand, like under the major questions doctrine, how does the authority in which they're doing it make any difference anyways?
Right. I agree. And I have a different read on what's going on here. So all of these decisions so far, the two decisions, have blocked mass debt relief by Biden, right? They have said you can't issue this sweeping, all-encompassing student debt relief, this one-time program. And that leaves a lot of wiggle room for the Biden administration to adjudicate these debt relief requests on a case-by-case basis. So let's talk about the HEROES Act. As you said, this was passed in the wake of 9/11. It is not strictly limited to 9/11. It talks about national emergencies. It defines national emergencies as whether the president has declared one. President Trump declared a COVID emergency that has not been undeclared, so it's still going on. And there is almost no way that a federal court could stop the Department of Education from looking at these applications one by one and stamping them with something that says this person was negatively affected by COVID and we are hereby relieving their debt. There is no court order right now that stops the Biden administration from doing that at this moment. And there is no rational justification under the HEROES Act for any federal court to step in and block individualized student debt relief. So my guess is that what the Biden administration did was take this moonshot initially, say, well, we're just going to see if it works, get as many people as possible to submit their application, so gather the data, and then eventually, once this is worked out through the courts, start going person by person and relieving their debt on a case-by-case basis instead of all at once, and that'll be the end of it.
Were they collecting enough data? I mean, because as far as I understand it, Matt, wasn't it just like you put your name in and your phone number?
Yeah, maybe email too.
I mean,
so They reach out, they have your contact information. I think it's quite possible that they reach out to you and
they
ask
send
you,
like a one question questionnaire. Were you harmed by COVID financially? A, yes. B, no. And if you say yeah, A, then boom, you've qualified individually.
Exactly. I mean, that's how the eviction moratorium worked. You had to sign a little piece of paper that said, if I am evicted, I will spread COVID in between the states. Like millions of people did that and did not have a problem with it. I foresee a very similar process for this. It will take a really long time. It will be very cumbersome. Some people will inevitably fall through the cracks, but there's just no way that a federal court can tell the federal government that it cannot discharge this debt that it holds. The federal government is holding this debt. It gets to decide what to do with this debt. And if it has to go through person by person rather than all at once, I think that's something that the Department of Education is ready to do.
And let's be clear, if they were to do that, what capacity would the federal government have? I should say, what ability would the federal government have to do anything in terms of its books? I mean, like, right. How do you justify raising taxes? How do you justify doing anything?
Right. And I mean, the HEROES Act makes it very clear that you can discharge debt. Now, the question is whether you can do it on a mass scale. Courts are going to rewrite the law to say no. But as you said, there's all kinds of other laws, like thousands of them, that give different federal agencies the ability to manipulate monetary funds that are held by the federal government. And if federal courts intervene here, there's no logical limit to where they'll stop. They're just going to keep doing this. I don't think that the Supreme Court wants to spend the rest of its time on this planet adjudicating every penny of federal money that is spent or relieved or canceled. So I just don't see a way around this for even the most radical federal judges.
All right. And so when do you anticipate this getting up to the Supreme Court?
We don't yet know.
In its current form. I
don't know if the Department of Justice will appeal the Eighth Circuit's preliminary injunction to the Supreme Court. Maybe it will. I could understand political considerations. If I were a DOJ, I would think very carefully about working this out in the lower courts while you're still collecting all of this data from individuals, encouraging people to submit applications, go to trial in the lower court.
They've stopped it. My understanding is they've stopped the applications as of a good day or two ago.
Okay, they didn't stop it initially. I guess they've stopped it.
I think
recently.
they stopped it. I think they stopped it in the wake of the Texas ruling.
Well, they should continue because that is the information that they're going to use if they're going to get anything done here. But I think there's a good chance that the Eighth Circuit decision will get appealed to the Supreme Court, and we'll get a decision on the shadow docket sometime before New Year's.